Lewani Lino processor ne
Good.
ele processor mood and mood
Advocate Ramano. Also welcome the members of the media. Before we proceed, can we just receive apologies?
Chair, the only apology that I have is from Mr. Wintering of the ACDP.
Raise your voice.
One apology from Mr. Thring from the ACDP.
Mm-hmm. And which parties are not represented now?
At the moment, I don't see the EFF.
Did they apologize?
No, I've not yet received an apology.
Were they present yesterday?
I don't, there was a Mr. Tambo, but the member is Mr. Shivambu, but I don't remember seeing him on the platform.
But there was one from them?
Yeah, he joined us briefly.
Okay, no, that's fine, that suffices. Honorable members, I need to place one or two things on record before we start with our deliberations. You will remember that yesterday we said the purpose of this meeting today is to receive and consider the report prepared by the administration on the basis of the submissions made between July and the 13th of August, which was given to us by Parliament to proceed with our work. And secondly, that the management committee took the initiative, given the constraints of time, to produce a draft, a revised bill informed by the submissions, so that when we discuss the report, we discuss it in conjunction with the draft revised bill, because time is not on our side. But I think the administration, the management committee did that with a full understanding and acceptance of the fact that you are the principals in this matter. But now those are the two documents that we'll place before you for consideration. But with, as I said yesterday, with regard to the revised bill, quite obviously, political parties will need to go back to their principles to take further mandates. But with regard to those mandates, I want to refresh the minds of the honorable members in my opening statement, which says, our constitutional democracy is based on the doctrine of the separation of powers between Parliament, the executive, and the judiciary, Parliament adopt rules which regulate the exercise of its powers with due regard to the dictates of the spirit and letter of the Constitution and the rule of law. A reading of the Constitution as a whole makes it clear that our Constitution is the creature of the people. The people are not the creature of the Constitution. Hence, the Constitution itself allows Parliament to amend any of its sections subject to conditions it sets out. For instance, that the amendment of Section 25 requires a 2/3 majority of the members of the National Assembly. This, however, does not make the Constitution the creature of members of the National Assembly. This is so because our constitutional democracy is both a representative and a participatory democracy. This means further that when it comes to the amendment of any section of the Constitution, members of the National Assembly, regardless of their ideological and or party political policies, have no final say. They, the creators of the Constitution, that is the people, have a final say. Thus, the Constitution makes public participation a mandatory requirement, and where Parliament fails to conduct meaningful public participation, the concord invalidates the law passed by Parliament. This means that the people are the creators of the law or the final arbiter in case the political parties do not agree. As political parties, we may not collapse a legislative process because we fear or suspect that one of us will deny us a 2/3 majority. This ad hoc committee does not need a 2/3 majority to decide. It must therefore not collapse because because one of the parties does not cooperate. We must conclude our business and report to the House. Finally, the people will judge for themselves as to who are acting in their selfish interests other than the best interest of the people of South Africa as a whole. I believe that the programming committee had good reasons to give us a 2 weeks extension. Unfortunately, they did this without the benefit of the report and recommendations contained in the report before us, but this should not prejudice this process. This report shows that the parties in this committee have not been loyal to their own decisions. We repeatedly said that our original mandate was to review all subsections of Section 25. The limitations in a limited number of subsections came from the compromise original bill. We sought to cure this defect by requesting a 3 weeks extension to consider the revised bill. Some parties in this committee said they didn't have the necessary mandates. Hence, during the 3 weeks, we were granted subsection 225(7) on the cutoff date and the status of the communal lands were not addressed. The submission that have come in will show that these matters must be addressed if we have to address the injustices of the past, which dates back to the 1800s. The critical question we have to answer today is whether or not we are going to disregard the outcome of the public participation. I want to submit that if we do, we will be violating the principle of participatory democracy, which is a very important pillar of our constitutional democracy. If we consider the outcome of the public hearing, as we are obliged to do, we must act in terms of the rules of Parliament. not in terms of party political mandates or ideological positions. The rules of parliament take precedence over the ideological or selfish interests of political parties. The outcome of our discussion of the report before us will therefore have an impact on the question whether or not we are going to disregard the principle of participatory democracy for political expediency. That is why the Management Committee instructed Parliamentary Legal Services to produce a revised bill informed by the report before you, not by party political mandates. The two documents must be read together in order to answer the critical question whether or not we disregard the principle of public participation. We must provide a source of our authority to do so. Our report to the House after the expiry of the 2 weeks must show that we understand and embrace the supremacy of the Constitution and the law and the rules of Parliament, and that they take precedence over our selfish and or ideological party political positions. As you go to seek mandates from your political principles, bear in mind that no political party, however big or small, is above the Constitution, the law, and parliamentary rules. As parliamentarians, we are obliged to apply the Constitution and the law without fear or favor of our political principles. All political parties, however big or small, are subject to the Constitution and the law, and we must therefore conduct the business of this committee in terms of the rules of Parliament. I trust that these opening remarks will empower ourselves in the consideration of the two documents before us, and I thank you. Honorable members, I see two hands. Honorable Lotrich and Honorable Dr. Mulder.
Thank you, Chairperson. Although I did see that
raise your hand, your voice.
Chairperson, thank you, but I did see that the Honourable Mulder's hand was raised before mine, so if he would like to go first, he is welcome.
No, I think Honourable Mel is a very understanding man. You are already on the platform, so proceed.
Thank you, Chairperson. With regards to your opening statements, it is very clear that this committee has been treated with utter contempt. Your explanation of the management committee having taken decisions in terms of extensions, in terms of a revision of the bill that was submitted for public content, does not hold, because there was nothing that prevented you from calling a meeting of this committee to decide on those matters. It is irregular, it is not procedural, and there is no way that you can now try to convince us that there are certain parties who are acting in selfish interest and don't have mandates. Yes, we have mandates, and it is part of the democratic dispensation that we may object to things. Chairperson, we would not have been here, we would not have had a meeting if I didn't start inquiring from the Secretariat exactly why. Yes, let me rather also put on my video so that you can see me. When I started inquiring why there were organizations already receiving invitations for oral submissions after the deadline for this committee, it was only then that all of a sudden a meeting was convened. So clearly, Chairperson, and I have to stress this, there was no intention to involve the committee. It was a decision taken by yourself and staff members. This is not how it should work. So I take serious umbrage at the fact that you now accuse political parties for objecting to procedure. You started with the Constitution and public participation. We fully agree with that. But then it must be in terms of rules and what is expected of us as a committee. This has not been done. This committee has been sidelined. So I want to put this on record, Chairperson. What we're doing is unprocedural. We have had more than enough time. The submissions closed on the 13th of August. We could have met the next week. We could have received those submissions earlier, immediately when they were received. We as a committee have the task to go through those submissions and decide on what exactly is included, or if in any case anything must be included. This was a cherry picking in terms of the submissions. Some of those matters included in the revised bill is only mentioned by one submission. We have read those submissions. And quite frankly, Chairperson, the process that we're doing now is procedurally irregular and also substantively irregular. Thank you.
Dr. Lotrich, with due respect, the extension was not requested by the management committee. I personally heard about it in the meeting yesterday from members of this committee who are members of the programming committee. And the revised bill was produced by the Parliamentary Legal Services on the instructions of the MANCOM, which was informed by the fact that time is not on our side. And the reason we have a management committee is because it must provide leadership, taking into account the circumstances prevailing, provided we don't breach any rule of parliament. And we have not breached any rule of parliament because the revised bill is not binding on the members. It is just an aid to fast track the process. And I can go further to say, actually, that revised bill flows from the report that we're going to discuss today. And if there's anything in the revised bill that does not arise from the report, the members have the liberty to raise that, and the necessary corrections will be made. And I am not accusing any political party of acting in their selfish interests. I am saying that the nature of this process is such that no party should act in their selfish interest, because this process is a process that ultimately is going to depend or depends on the will of the people of South Africa. So as I have consistently said, when we deal with this amendment, we must put aside our party political interests or ideological positions and put the interest of the people of South Africa above our selfish and party political interests. And I don't agree with you that we could have convened a meeting much earlier. And I don't agree with you that we convened this meeting as a result of your communication with the administration, which anyway you didn't have the right to do. We had the only chance of convening this meeting after the report and the revised bill were completed. Now, the first opportunity that we could convene the meeting was yesterday, because the report and the revised bill were ready. So I really want to appeal to you that actually members of this committee should not usurp the work of the administration. For instance, when the administration have received 148,000 submissions, it's humanly impossible for this committee to sit and go through 148,000 submissions. And we never did that before. What we did was that the administration goes through the submissions and prepare a report for us. And this is what has been done. So there's nothing irregular in this process. We should not, waste time, dealing with suspicions and other things. This process is quite regular, is clear, and it must proceed. Honorable Dr. Mulder, and then you'll be followed by Honorable Mahlatsi.
Yes, good morning, Chairperson. Good morning, colleagues. It's Friday. I love Fridays. Chairperson, do I have your attention? Because I see you're busy with another discussion. Chairperson.
So you are not audible. Can you raise your voice?
Thank you, Chairperson. Yes, I will raise my voice, Chairperson. I hope you can hear me now.
Yeah, I can.
Chairperson, you are a very senior Parliament, and you've been around for many, many years, and I and you have served on many, many committees. It goes way back, even to the Nkandla report and others. And I've got huge respect for you, and I would like to use the opportunity to also just put some things on record. I find the discussion fascinating. It's a deep philosophical discussion, which I think is very good. If I may say, for what it's worth, my own doctorate in law is in constitutional law, so I listened very interestingly to your interpretations.
Mine also is in constitutional law, so we are in the same boat.
We should have a discussion. So,
yes.
Let me put it this way. I understand, and we all know that from day one, when you were elected as chairperson, you made it very clear that you are absolutely committed to try to steer the committee for all of us to come to an agreeable solution. I understand that, and I understand the bona fides in which you did that. And that's fine, I understand that. However, you've started off by taking us to the provisions of the Constitution, and you mentioned the whole question of the separation of powers, you mentioned the rule of law, and then you made the point that the Constitution is a creature of the people. I agree with that. However, I still maintain that we should also have a discussion at some day what we mean with the people. We cannot be selective in interpreting who the people are. The people are more complicated than we may perhaps think. You also made the point that we have a representative and participatory constitution. That's correct. However, if you look at Section 1 of the Constitution that deals with the founding provisions, you won't find participatory constitution in the founding provisions. It's not there. I think the problem to a certain extent is that we cannot be selective in what we do. So you also made the point when you said we cannot disregard the outcome of public participation. That's what you said, Chairperson. But we cannot be selective in doing that, because then we have to take on board all the public participation. We can't just go and take out this point or that point and put that into something else. You also just now made the point that we couldn't meet earlier because the revised bill was only completed yesterday or the day before. But Chairperson, isn't it up to the committee to revise the bill? Isn't it up to the committee to discuss the public participation and the inputs that we received? And then for the committee to decide whether there should be any revision of the bill or not. I understand you took it upon yourselves because you feel very strongly that we need a successful outcome, and you asked the legal team to come up with a revised bill, and that was presented to us yesterday. I think we should deal with the facts, Chairperson, and I'll come back to that in terms of the reality. Whether we like it or not, I think I was not in the House yesterday. We were all in this committee, but I understand that a 2 weeks extension was granted by the House. So we've got a 2 weeks extension to deal with the outcome of this whole process. But you made the point to say that the people are the creators of the law. The people are the creators of the Constitution. Yes, absolutely. And then you made the point and said, But political parties can't now come along and defeat the whole exercise by withholding their support and preventing a 2/3 majority. We cannot subvert the will of the people. But Chairperson, it was also the will of the people when we wrote the Constitution to put certain provisions in the Constitution. And let me just refer you to Section 74. Section 74 deals with bills amending the Constitution, and it gives certain thresholds. And when it comes to Chapter 2, we all know that there's a 2/3 majority needed. We all know that. But that's not my point. Section 74(1) goes even further. It says Section 1, and that's the section that deals with the founding values of the Constitution. Supremacy of the Constitution, rule of law, we all know those. But Section 1, and this subsection, the one that says how we amend the Constitution, may be amended by a bill passed by the National Assembly with a supporting vote of at least 75% of its members, and National Council of Provinces supporting vote of at least 6 provinces. The point I'm making is this: whether we like it or not, we cannot now come along and say, we've had public participation, and in that public participation, we have now cherry-picked 1 or 2 issues, and we've asked the legal people to put that in a revised bill that did not go through the committee. It was not discussed. We haven't discussed anything. And then we say, but the people now participated and they say they want this, and we cannot allow the provision of the Constitution that says we need a 2/3 majority unless we want not to be able to amend that section. But it's worse than that, Chairperson. You are now suggesting that even Section 74 becomes a problem because this 2/3 thing is a little bit of a nuisance. But it's not that simple. I've just read to you 74(1) that says if you want to change the mechanism that says we need a 2/3 majority, you need a 75% majority. And those are the 2 most entrenched provisions in the whole Constitution, Section 1 and Section 74, that says how do you go about amending the Constitution. And those provisions were put into the Constitution by whom? The people. So we can't just cherry pick now and say we've had a different participatory project. Chairperson, I give you all the credit that are due in terms of your absolutely committed endeavor to try and bring a success to this process. But in the end, our dispensation and the Constitution also decided that the people are represented by political parties in the National Assembly. And there we are representing the people, all the people, from our different power bases. And Chairperson, regardless of what happened up to this point, we've got to deal with the reality now. We've got 2 weeks extension. Let's go through the process. You've decided to bring a revised bill. I don't know what we do with that. We've heard yesterday that if these things are in this revised bill, we need to have further participatory democracy. Yesterday I said we were absolutely in quicksand. So let me conclude. Chairperson, I've got huge respect for you, but I think we are going around in the wrong direction at this stage. Let's complete this process. Let's take it to the House. Let the House take a decision in the end after whatever comes out of this committee. And that would be the process. Why? Because that is what the Constitution says, and that is what the people said when they sent us to Parliament in the last election. Thank you, Chairperson.
Dr. Melda. Dr. Melda, I agree with much of what you are saying on the philosophical questions. The cherry picking, wrongly or rightly, is informed by what has been happening, but that does not preclude the committee, doesn't usurp the right of the committee to say this revised bill should have included the following things. That's a prerogative of the committee. So the suspected or perceived cherry picking will not in any way prejudice members of this committee. So don't worry about that. But also, there's no intention on my side or management committee or anybody to change the mechanism which says decisions must be taken by the 2/3 majority. So I agree with you that all that we need to do is to continue with the process, produce a report, and go back to the House. The House will take a decision. So I agree with you on that score. And that's why this meeting today, it's important for the members of this committee who have been given the report in advance to read the reports and adopt it or accept it as a working document, and then also look at the revised bill. Actually, there's not much that we can do with the revised bill, but members will be free to suggest this or that, which will be noted. But the important thing is that we want members to go back to their political parties, as you correctly say, to get further mandates. Because in the past, this question of mandates has actually created problems for us. Parties come to us when we have to take decisions based on the law and the constitution. Parties say we don't have yet a mandate. And that's why we are in this problem about Section 25(7) and the Communal Land Acts, because of this lack of mandates. Now, this time, we will have to agree that is the final opportunity to get mandates, and the process has to move forward, and we prepare a report, take it to the House. The House will guide us, because Parliament has to, and we in Parliament, we must apply the law and the constitution. In doing that, we have to do it without fear or favor of our party political principles. And if you listen to the proceedings at the Zondo Commission, you will understand that we are an independent institution. We cannot act on the instructions of anybody other than the law and the constitution. And that's what we're going to do. But despite that, we are not going to deny parties the right to seek mandates from their principals. Honorable Mahlatsi.
Thank you very much, Chair, and good morning, colleagues. You know, Chair, it seems like we were not in the meeting yesterday, precisely because yesterday we agreed in principle that today we're going to get a presentation from legal services and thereafter determine, based on the presentation that will be tabled before us, whether there is a need for a third draft or not.
So can you raise your voice? I can't hear you.
Chairperson, I'm saying yesterday in the ad hoc committee meeting, there was a general consensus amongst all members of the ad hoc that today we're going to receive a presentation from legal services based on the inputs that have been received from the public participation process. And thereafter, after deliberations on the presentation, we will therefore determine whether there's a need for a third draft or not. And furthermore, we agreed that next week, Tuesday, ourselves as a representative of different political parties will go and seek mandates if there is a need for a third draft. That's what we have agreed upon. Now, I don't understand why are we discussing the issue that has not yet been put before the meeting for us to deliberate on. Unless colleagues are aware of the inputs that would have been made and the rationale that would have been made by legal services. For purposes of progress in this meeting, can we kindly get a presentation from legal services and take it from there? And if there are issues in relating to the third draft, they will be discussed next week, Tuesday, when we will have our meeting to discuss whether we are taking it forward or not. Thank you very much, Chair.
Honorable Mahlatsi, I can agree with you more. You correctly captured what happened yesterday. But as the chairperson, I had to highlight or remind us that we are bound by the constitution, the law, and the parliamentary rules in case one of us has lost sight of that. But what you are saying is perfectly correct, and therefore what I'm going to do, because I see some 3 hands, those would be the last hands, and then we move in terms of what you are saying, because you are perfectly right. Honorable Bredenbach.
Good morning, Honourable Chairperson. Thank you very much. Yes, I'd like to align myself with the comments of the Honourable Lottridge and the Honourable Mulder, and add, Mr. Chair, that you and I also have a long background. We have worked together on many committees, and I hold you in the highest regard. I must differ quite sharply, though, with your summary of events. I emphasise the inputs of the Honourable Lottridge that procedurally there's something seriously amiss here. This committee was not involved in the sifting of the public participation results. We did, in fact, go and have a look at the public submissions that first came in. The new ones we have not seen. I would like to see them. I hear you say it's impossible to go through them. I differ. It is entirely possible to go through them, and it's not our job to rely on, however well the job is done by the administration. It's not our job to allow them to do our work for us. We're members of Parliament, there's requirements of us, and we should make a concerted effort to do the job ourselves. So I personally would like access to all of those submissions, and I'm happy to do it before next Tuesday. Procedurally, there's a serious problem here. It appears that either yourself or the management committee, which is some ethereal creature, or the administration have made decisions on behalf of the committee that the committee were never consulted about. And I find that objectionable, but we will deal with all of that next Tuesday. Thank you.
Thank you, Advocate Bredenbach. I think in terms of what Honorable Matlati said, we have to be loyal to our own decisions. We decided yesterday what we are going to do today. So this is not an opportunity to change the decisions of yesterday. We have to be loyal to those decisions. But procedurally, I have explained why we proceeded as we did without usurping the powers of this committee. So if there is anything untoward or a defect, it is curable. And that's why we have brought this report and the revised bill to yourself, so that we can cure the defects which were occasioned by the problem of the time constraints that are facing us. The last word, the last hand before we move on is Honorable Steyn.
Thank you, Chairperson. Chairperson, I was part of the meeting yesterday, and I remember that we said that we're going to deal with the committee report today, Chair. But I do think it is very important for us as a committee, Chairperson, to understand the process of how the third draft of this bill landed on the table. I know we're only going to discuss that today, but I have a serious problem with the fact that with the notification of the meeting for yesterday, we have received the third draft of this bill. This third draft is already in the public domain. Our meetings is open to the public and people have access to it. People are asking me, how did you decide on this? How did this happen? And I said, no, well, I'm a member of this committee, but I have no clue. So, Chair, I think before we move to the committee report, or even while we handle the committee report, I think it is quite important for this committee to understand exactly how this process unfolded. Because, Chairperson, it feels to me like I'm a rubber stamp here, and I know that you said, because of time constraints. The fact of the matter is That was supposed to be discussed by us. Yesterday, the House agreed to a 2 weeks extension. But before that agreement, there was something published to say that we're going to have a 2 months extension. That could have given us time in any case if we had discussed it. So, Chair, for me, it's very important that we understand the technicalities of this. I've been a member of Parliament not so long, but it's 12 years now, and I've dealt with a few pieces of legislation during this period. And never before have I seen that we get a new draft version of a bill before the committee haven't discussed this, the previous one. Chair, so procedurally, I just need to understand all of this, and I'm not sure who will be able to give me that assurance of the process that was followed. Thank you, Chair.
With due respect to you, never in my life have I ever seen the committee drafting a bill. The Parliamentary Legal Services draft the bill, present to us for consideration, approval, or rejection. And the work of Parliament is not done in the closet, it's done in public. So if a bill has been produced and presented in Parliament for discussion, there's nothing wrong with that. You must explain to those who approach you that Parliament does not work in secret. That's why even the revised bill was brought. But the fact that the revised bill was brought before the committee doesn't mean that the committee has adopted a revised bill. It only means that it is put before them for consideration as we agreed yesterday. So you should not worry about that, because that bill is just a draft to facilitate discussions, because we have time constraints. I had said that I'll take the last hands, but I don't want to suppress members, but I'm not going to allow more hands after these two that I see now. I'm going to recognize Dr. Gondwe. She came first, and then Honorable Suma will be the last, and then we move on as proposed by Honorable Mahlatsi.
Thank you very much, Chairperson. Chairperson, while I share your sentiments around us not wanting to, belabor this, any longer, we have to understand, and we've said this from the beginning, we have to understand that we're not amending an ordinary piece of legislation. We are amending the Constitution. And I think the decision by the management committee really doesn't, for me, it shouldn't have excluded the committee as a whole taking a decision on this matter, given the fact that we are amending the constitutions, and there are serious apprehensions about this amendment from the people, our people, some of our people. And I honestly feel that we should have been confided in around the fact that we need to take a decision around these submissions that we've received. And so I honestly think that really trying to rush this process, I'm not entirely sure why we're trying to rush it. And at the end of the day, some of us have felt excluded and felt that decisions are being taken, and we need to all feel involved in this process. And I'm not entirely sure why you could have not confided in us around, this third draft. Thank you very much, Chairperson. But we are really concerned about the fact that, the management took a decision without, feeling, the need to consult, and make this process as participatory as possible. Thank you very much, Chairperson.
Dr. Gondwe, like Honorable Dr. Milda and myself, you hold a doctorate in law. You should be able to distinguish between technical work and substantive work. The management committee instructed parliamentary legal services to prepare a technical document for consideration by yourselves. They did not deal with the substantive issues. That is the prerogative of this committee. So let's not waste time on that because you have not been prejudiced. Honorable Suma, you are the last one.
Thank you very much, Honorable Chair, and good morning, colleagues. I missed you yesterday, but I've just observed I was not going to raise my hand, but I can see that everybody wants to support the person that would have made a suggestion that seems to give us a way forward. Let me say it upfront, Honorable Chair and colleagues, that I fully support the proposal and the suggestion made by Honorable Matlati and amplified by your good self, Chair. If we are really alive in terms of that, we are dealing with the Chapter 2 of the Constitution that and we want to be clinical as possible. If it was for me, I wouldn't have commented to your opening remarks, Chair. Whether we agree or not, I would have expressed my view when we're dealing with a substantive matter. That I think for me, I need to register that. Secondly, Chair, I know we've got lots of things, then we tend to also to forget. I don't want to be rude and say deliberate, but to forget that even the first draft that was as a compromise we agreed on, it was drafted by legal services and we never said anything. We're comfortable with that. And I see no issue even on this one. It's up to us whether do we accept it or do we reject it. And then my humble appeal, Chair, let's proceed and deal with the intended substantive issue of today's agenda items, noting that also in terms of sharing all the submissions that have been made, if I may use carefully inverted commas, the second draft, if I may use that one carefully, submissions then can be shared with all of us. And I'm sure that the administration is ever ready also to walk us through how to get those ones if the technology fails us in some instances. But other than that, Chair, I will really make an humble appeal that let's proceed so that we can have the process where we need to take a decision. We will take a decision where we feel that we want to go back and put our brains as various political parties. We'll register that accordingly, Chair. Thank you very much for the opportunity.
Thank you, Honorable Suma. I think you have been clear. You made it clear that from the outset, parliamentary legal services have been drafting bills and what's wrong. And when the management committee goes to the same structure that is responsible for drafting and say, do draft even in this case. Thank you very much. And I have said, Dr. Bondwe and yourself are the last. Now we are moving to the program of the committee, which was agreed yesterday, because my opening remarks are not on the agenda, but I had to put certain matters on record so that we are reading from the same page and singing from the same hymn book. Now I'm going to request legal services to present the draft of the administration. Dr. Tulisile, who is going to lead us?
Thank you, Chairperson. I will be presenting on the report on written submissions.
And just make sure you raise your voice. And I know it's cold, it's strenuous, and people have flus, and sometimes the voice doesn't come out quite clearly, but try your best.
I will, Chairperson, and I also need to apologize upfront that I have a flu. So if those hiccups come up, please, members, say so that I can repeat myself. I will try and share the screen now. I'm not sure if I can. Can members see the presentation?
Yes.
Thank you very much, members. This is the presentation on the second call for written submission on the revised Constitution 18th Amendment Bill. Chairperson, as introduction, this is just stating the mandate of the committee as it was mandated by the resolution of the House to actually start this process. In terms of the background, the members would know that the committee received and deliberated on a report on public participation in the past. And they also considered and deliberated on legal responses to the legal matters raised in the report at the time. And consequently, the committee made substantive and material amendments to the bill. So the revised bill was then advertised.
Sorry, Doctor.
Yes, Chair.
I thought that what we need now is a presentation of the report and then the bill later. Is that what you are going to do?
Yes, that is what I'm doing, Chairperson. This is just the background to the presentation itself.
Proceed.
Yes. So we advertised the bill in July 2021 with the closing date of the 13th of August 2021. So the purpose of this presentation is to highlight the views of the public on the revised bill. The revised bill concentrated on 3 issues. That is, the national legislation must provide circumstances where the amount of compensation is nil. Secondly, that land should be a common heritage of all citizens that the state must safeguard for future generations. And lastly, the conditions should be fostered to enable state custodianship of certain land in order for citizens to gain access to land on an equitable basis. In terms of the submissions, Chairperson, we're at the closing time, we received 148,891 submissions. And looking at the submissions, we actually received submissions that were submitted to the Constitutional Review Committee processes in 2018. We also had resubmissions that were meant for the first call for submissions to the bill itself. And also we received submissions on the expropriation bill before the PC Public Works. And these submissions were actually not relevant for this particular process. And we also received submissions from bulk email addresses supporting one submission. And I just need to say that the Institute of Race Relations, we received bulk submissions from them before, but they were actually related to the first call for submission. However, we received emails that were titled Institute of Race Relations in bold capital letters, and these were new submissions for this particular bill. And we received some submissions from DASA and AfriForum as well. And we received substantive submissions from individuals and organizations on the revised bill as well. In terms of matters emanating from these submissions, the first one I'm going to deal with, Chairperson, is actually the preamble. The preamble was actually said to be misleading in a sense that 90% of land claimants opted for financial rewards when it was actually opened at the time. And there was no evidence that the amendment of Section 25 will ensure access to land and empower the majority of South Africans. Also, it was felt that it was inappropriate to refer to productive participants in the preamble, because that implies a reference to agricultural land, because that is not the underlying objective, but rather the underlying objective is about correcting historical imbalances around land ownership. And also it implies a restriction on access to land, not only those productive who can actually access land. And also the preamble focuses on the dispossessed people. And it was felt that it should speak to all the people of South Africa, not only the dispossessed, because it actually negates the important place of the land tenure programs that were implemented by government. With regards to state custodianship, submitters felt that there is a requirement for a clear definition of what state custodianship actually means, with clear roles and responsibilities. And that state custodianship, it affects the right to private property ownership, and it needs to be reconsidered. And also that people will then be subjected to eternal leasing of land should state custodianship be part of this bill as well. So the right to private property ownership is actually the key pillar of the rule of law and founding principles of the Constitution. And some noted that with state custodianship, there would be economic losses as a result of expropriation without compensation. Also, submitters felt that the Ingonyama Trust model, of which the state custodianship was actually likened to, was viewed as dysfunctional and should not be replicated throughout the country. And they noted the recent judgment against the trust, which highlights the inherent dangers of centralized land ownership. And state custodianship was also equated to nationalization of land, especially with the lack of clear definition, and imposes a significant risk to the banking sector as well. Some submitters felt that there's no security of tenure under state custodianship, as evident in the proactive land acquisition strategy. Also, land as a common heritage, it introduces state custodianship, and that these words should actually be removed from the bill. And it also appears to look at land as a natural resource rather than regulating ownership. So the property rights also cannot be vested in future generations that are still to be born, according to the submitters. So Section 25(5) of the Constitution is viewed as an empowering provision, and that state custodianship severely limits the discretion in that clause, and it restricts government to single model of state ownership to achieve land reform. So it runs the risk of limiting the state with regards to policy changes to achieve land redistribution in the country. When it comes to nil compensation and expropriation without compensation, we're just looking at nil compensation. Submitters felt that they actually noted the supremacy of the Constitution and felt that the amendment stating circumstances in determining the amount of compensation refers to national legislation, thus making the Constitution subservient to legislation. And that undermines constitutional safeguards provided for in Section 74 of the Constitution. Nil compensation is also regarded as confiscation of land, unjust, and deprivation of human right to own private property as well. Especially from the farming sector, they believe that this would lead to unwillingness to invest in property if there is no guarantee to ownership for the duration of the investment. So it will also reduce domestic and foreign investment in land. And also, the committee was requested to actually reconsider the inclusion of improvements on land, and also because it is understandable that nil compensation relates to social justice. However, the inclusion of improvements on land that will then be expropriated, that needs to be considered. So should the legislation prescribe nil compensation as an absolute requirement by using the term is instead of may, it will inadvertently oust the jurisdiction of the courts to determine what is just and equitable with regards to compensation. With regards to expropriation without compensation, Government is actually urged to use undeveloped land for economic development, and that this is the permissibility of land reform must be set out as a closed list in the Bill of Rights. And also submitters expressed concern over non-exemption of property used for religious purposes for expropriation without compensation. And that expropriation without compensation is also accepted as a way to make right a historical injustice. So expropriation without compensation is also seen as land grab that will end in famine, economic devastation, and despair for citizens. Hence, the committee is requested to actually look at these issues as well. And some submitters felt that this provision was racially motivated and it undermines international law and fundamental human rights enshrined in the Constitution. It also inhibits access to finance and by extension to housing as enshrined in the Constitution. With regards to the role of courts, some submitters felt that the revised bill is actually advocating or the removal of judicial oversight. So Parliament actually interposing itself by taking the role of determining the amount payable as nil. So by so doing, then they discard or disregard the court and the legal system of the country. And that the role of court as an arbiter between the state and citizen is actually eroded with this bill. So Section 3A, which actually is about determining circumstances where compensation is nil, and that there should be a replacement of is with may to avoid violating Section 34 of the Constitution. And also that the determination of nil compensation cannot be reduced to mathematical calculations only. It is rather contextual and require weighing individual rights against the fiscus of the country. And now I'm noting some comments against the bill. The first one is that the amendment to the Constitution is unacceptable and promotes threat. So the amendments pose a risk to individual civil liberties and human rights. Secondly, that secure land rights are an important pillar for agriculture. So in the face of an increasing global demand for food, there is a need for a comprehensive global strategy necessary to ensure sustainable and equitable food security. And again, secure land rights are also essential for urban development. With regards to that, the submitters indicated that cities must create more affordable and livable urban environments to formalize land markets, clarify property rights, and institute effective urban planning. And lastly, on this slide, is that secure property rights help protect the environment, and government needs to develop policies that improve tenure security in forest areas and allow the transfer of land used in non-environmentally sensitive areas to agriculture and other production. Also, with regards to secure property rights and access to land are crucial for private sector development and job creation. So the private sector actually needs land to build factories, commercial buildings, and residential properties as well. And also, secure property rights are important for empowering women. So government must develop a legal framework that fully supports equal access to property ownership and use of land titles as collateral without a male guardian. And also, secure property rights help secure indigenous people's rights So the need to recognize the indigenous people's land rights as human rights issue, which also makes economic and environmental sense. Some submitters felt that the amendments actually exceed the recommendations by the Constitutional Review Committee and limit the scope of the constitutional amendment in two ways. One, it provides for only a change that makes explicit that which is already implicit in the Constitution. And secondly, it provides the state with new powers that it does not currently have. And some comments in support of the bill. There was the issue that we need to address the 1913 land disposition, where government of the day took indigenous people's land without compensation. And that land disposition was equated to land theft by the government of that day. So also there is an urgent need to allocate land to the dispossessed people by a transfer of all land under traditional leadership to owners with full title deeds. Another point is the redistribution of land and wealth has a positive impact on the overall economy of the nation when allowed to flourish without negative pressures from illegal international embargoes. And that land claims before the 1913 date be considered, and that qualifications to be set must be in compliance with the United Nations Declaration for Indigenous and Tribal People, the customary law, and the Constitution not to consider the native titles matters. And lastly, on this slide, is that the return of stolen land as required by the United Nations 1945 ban on illegal annexation and occupation is actually consistent with democratic and Christian values. So the expropriation of land should therefore begin from the arrival of whites in South Africa, and the Land Act of 1913 must not be used as the baseline for returning the land to the lawful owners. Currently, the state has no adequate budget to speed up land restitution in order to redress the injustices that took place almost 3 centuries ago. Allowing the courts to play a major role in determining the amount of compensation will result in further delays, as court processes can take up to 20 years to conclude. So the committee needs to look at those as well. So the current legislation demanding payment of compensation delays the process of land restitution to its owners. So property evaluations and other related processes cost government a lot of money and have proven to be costly. Submitters also noted the contradictory and restrictive language within the bill. They noted that the preamble refers to empowering people to be participants in ownership. So there's a contradiction as to the rest of the bill that emphasizing state custodianship and the notion of the land as a common heritage of all citizens that the state must safeguard for future generations. Also, it uses the terms productive participants, and this implies a restriction on access to land based on productivity, and that it is against the restitution programs already implemented by the state, and that the same restriction does not apply to common law ownership. Thank you, Chairperson.
Ayamnandi indaba. Hey, awusiphindele futhi dokotela.
Thank you, Chairperson. I'm done. Chairperson, you are mute. Chairperson, your mic is mute.
Advocate Bonani, check the chair. Where is he so that we can proceed with the meeting? Or advise him to unmute himself.
The chairperson is in transit.
I think, Honorable Doctor, the system has kicked him out. Oh, there he's coming back now.
The system hasn't kicked him out. He's been all the time. Just
Hello.
Oh, you are back.
Hello.
Thank you very much, Chair.
Yes, can I have hands now? Who is on the floor? Honorable Suma?
There's no one on the floor, Chair. You are, and Dr. Lotric has her hand up.
No, Honorable Suma was on the floor.
No, Honorable Chair, I was just advising you that we lost you for a minute and you are back. We are very excited. Honorable Lottery, she's on, her hand is up. Thank you very much.
Thank you very much. Honorable Dr. Lottery.
Thank you, Chairperson. And also thank you to, let me just put this on, Dr. Tuli for her presentation on the submissions. Chairperson, yes, I would say on the whole that would be a fair reflection of submissions. And I know that Advocate Romano sent us 70 odd submissions as well, which we have studied. My question, Chairperson, based on what has just been presented to us, I don't see on what is included in this revised bill is not reflected in this presentation.
Sorry, Dr. Lottery.
So,
Dr. Lottery,
yes.
Just in terms of procedure, can we first allow all members to express themselves on the report, and once we are sure that everybody is satisfied on the report, then we move to check the bill, the revised bill in the light of the report, so that let's not conflate the two.
Okay, Chair, I will agree with that. Just to say that from my reading of the different submissions, I do think that it is a fair reflection of the comments made.
Thank you very much. And then we will come back when we come to the next item. Anyone who wants to express themselves on the report, Dr. Mulder and Dr. Masipa?
Yes, thank you, Chairperson. I would like to thank Dr. Tuli for the extract in the report. Obviously, the specific presentations made or the inputs made by the different institutions and individuals are more comprehensive. This is just an extract from that. I think it's a fair reflection. There may be one or two points that may not have been captured, but maybe so. If I may ask if we could be assisted by the administration sending us a copy of the presentation that we just had now for our own record purposes. Thank you.
Thank you, Doctor, Honorable Doctor Dr. Masipa.
Chair. Good morning, colleagues. Thank you, Mayor Tuli, for the presentation. The one thing that I just want to really get is this presentation regarding the first and second draft submission, because I'm not sure if it covers the third draft that is on the table now. If that can be clarified, Chair. Thank you.
No, it covers the draft based on the submissions of July to August the 13th. But obviously, the third drafts will have to be informed by what is this in this draft. But at the moment, we are dealing with the second revised bill, which was taken to the public. So what we need to do now is really to determine whether or not this report is a fair reflection of the submissions that were made. Ndata Masipa? Ndata Masipa?
Thanks. Are you giving me the floor?
No, I'm answering you. I'm saying we called for submissions for 3 weeks from July to the 13th of August. Now, this report is based on those submissions, which are 148,000 and more. And at this stage, we want to know whether the report is a fair reflection of the submissions. So we're not yet dealing with the bill. Honorable Lesoma?
Chair, can I come back?
Pardon?
Okay.
Yes, come back.
Chair, according to the report that we have received, the submissions, they were sent in about 5 batches. And when I did my calculation, they came to about, let me just check quickly. I think they came about to 96. But according to what Bonani sent, it's about 70. So where is the rest of the 100,000 that are calculated there? That's why I'm asking that question to clarify.
Okay.
Whether this submission of 140 odd are they for the first and second draft, because this submission for the 13 to the July to August is only 70 according to what Bonani has sent. Thank you, Chair.
Ndata Masipa, Dr. Tulisiwe explained quite clearly that some of the submissions received were irrelevant to our process because they were dealing with the expropriation, the proposed amendment of the Expropriation Act of 1975. So the administration and the lawyers had the right to eliminate what is not relevant, because sifting through the submissions is not the function of the committee. The function of the committee is really to determine whether the report is a fair reflection of the submissions, excluding the irrelevant submissions. Honorable Soma?
Thank you very much, Honorable Chair. Let me start by appreciating and the work, very tediously so, that has been done by the administration through your guidance, of course. If I can borrow from the previous public participation processes, how did we engage on as the committee? But also borrowing from the earlier discussions, which was triggered by your opening remarks, Chair, which had nothing to do with the substantive matter of the agenda item of today. I will say, instead of asking question, let's take it as in confidence that the presentation is a true reflection of the what public have submitted, and also how the categorization of the submissions have been done by the administration. Probably to put a rider instead of asking question to say, we accept it as a true reflection, and no way that was suggesting that we don't trust the administration, but in a spirit of consistency in the way we've been dealing with these matters. May we then be given the whole submissions to satisfy ourselves, and early next week we meet so that we confirm, or we make some suggestions in the report, so that it becomes our own program, as you correctly said, that we are the ones that needs to make a legal expression as the committee, whether we are satisfied. So I'm borrowing from our previous experience in terms of the road and the approach that we have been taken, and also the earlier discussions which had nothing to do with the substantive matter, that probably let's get that, and then the committee then will give us a roadmap. Early next week we can meet so that we can process the submissions and confirm or make any necessary submissions if we deem is necessary, Honorable Chair. Thank you very much.
Honorable Soma, I hear you quite clearly. But what I see here is that Dr. Lutrich from the DA say the report is a fair reflection. Dr. Mulder says the report is a fair reflection. And you yourself say is a fair reflection. Now, in the light of that, and I don't see any other hands, now can we really say we still need time to deal with the report when the majority in this House say it's a fair reflection? Can't we accept that this is a working document like we did before, but in case next week somebody has an addition, we can take that addition without reopening the debate on the report? Would that cover you?
Chair, you are frozen.
Am I frozen again?
Chair, can you recognize us on the chat? We have
Can
raised
you
our
hear
hand.
me? I'm not.
You're not frozen, Chair. We can all
You're
hear you.
frozen.
No. That's
No,
Honorable Soma is frozen. You're not frozen.
I'm not frozen.
You are
Okay,
not,
no,
Chair.
that's fine.
Can members hear me?
Yes, we can. We can hear you, Chair.
If everybody
Yes.
can hear you, then I can hear you. It doesn't
Yeah,
matter.
because I was really saying that Dr. Lutrich says the report is a fair reflection. Dr. Mulder said the report is a fair reflection. And Honorable Lusuma say there's a fair reflection. Is there anybody who takes a contrary view? Dr. Stein?
May I assist you, Chair, because I made it a slightly rider in terms of prolonging the process. If that's the case, Chair, because I was taking my point from what honorable members, Dr. Lottery and other members were raising. I was trying to be very much accommodative, but I'll retrieve that and say, let's proceed. Is from where we are seated, in particular myself and the ANC, is the true reflection of the submissions as it were shared by the administration to all of us, Chairperson. I will align myself with your conclusion. Thank you, Chair.
That is helpful because really we cannot come here next week and be discussing the report. Then we will be left with a few days before the expiry of the 2 weeks. And I think that we have sufficient consensus and agreement here that the report is a fair reflection. And I also just want to place it on record that whilst I guide the administration, I don't guide them on substantive matters, because that would be interfering with their work. So I distinguish my guidance or base my guidance on approach procedures, not substantive matters. So can we leave the matters there?
Chairperson?
Yes.
Yeah, I think you must switch off your video if you're walking around. We are now.
Okay, no, I'm just changing
Yeah. Okay. Chairperson, can I make a comment on the last question regarding the fair reflection of the report? Chairperson, I want to link on to what Honorable Masipa has said. And I think yourself then said some of the submissions were not relevant with the words that you used. And I understand that to be maybe an email that was, repeated or something like that. I think in order for us to just ensure that we follow due process, if the Secretariat can just make up the difference between the 70,000 of those that we received and then receive maybe in writing or exactly, what is the bulk of that submissions that we received, so that we don't say it's a fair submission, Chairperson, but we haven't received any information about the emails that was either repeated or the information that was repeated, so that we just ensure for ourselves that we're happy, although the report was a reflection of those submissions that we received. We cannot make comment on those that we did not receive. Thank you, Chair.
With due respect to you, we have a highly qualified staff that is dealing with these matters. We have 2 advocates there. We have Dr. Tulisile, we have parliamentary legal staff, and they took time and went through all the submissions. And if we, as the committee, were to repeat that process, we would need more than 2 weeks. And I also don't think that it is our function to do that. We have not done it before, and we are not going to do it this way. And let's accept that the majority in this committee are saying that the report is a fair reflection, and then we are moving forward on the basis of that, on that report. And if you want to vote, you can put the matter to the vote, but I can tell you that there's sufficient consensus on this, and there's a clear majority here. So let's not waste time dealing with concluded matters. Dr. Gondwe, what is it that you want to say? It's an old hand.
No, it's not an old hand. Chairperson, I agree with Dr. Lotford that the report presented by Dr. Thuli is a fair representation of the submissions, but I still maintain that procedurally there are missteps, and we should have gone about this differently. The committee should have deliberated on those submissions, and then we should have then decided on which to include in this draft. So I still maintain that procedurally there are missteps here. Thank you very much.
With due respect to you, for the past 2 years, we've been working on this process. We never did what you are suggesting we should have done in this case. So you are introducing something new, and that is not backed by the history of the committee and the operations of the committee. But we note your concern, but the agreement is that the report is a fair reflection of the work that the administration has done. So let's leave matters there and move to the second item. The second item is that the management committee instructed the Parliamentary Legal Services to see if the report that they have does not influence or impact on the bill. And the determination was that it does. And in the light of that determination, they produced the third bill. And that was upon the instruction of the Management Committee, taking into account the fact that time is not on our side. So there was no intention to impose a draft on yourselves. It was actually just to facilitate and to fast track the work of this committee. And therefore, also the fact that in this committee, members always say they want to go back to their principals to consult. And we felt as the management committee, if you have to consult, you can't consult on the report. You must consult on what we are busy with. What we are busy with is to amend Section 25. So to aid your consultation, we would give you a revised bill. So this is actually to empower yourself in your consultations. And I can tell you that we don't even expect that in this meeting, we can take a decision on whether or not we agree with this. What we can do is to say, we note the report, the revised bill as an attempt to empower yourselves in your consultation with your principals. And then we give you time to go and do the consultations. And last week we had proposed that we should meet on Tuesday because the consultations would start today. But I think Honorable Gumede, for good motivation, said, why don't we not cancel this meeting? And I think he was perfectly right that this meeting must continue because now we have accepted a report. Now we are ready to move to the second stage. The second stage is now to deal with the revised bill. But in dealing with the revised bill, we need consultations with our principals. Then I would suggest that maybe we say we will meet on Wednesday next week, and then from the end of this meeting until Tuesday, all consultations must be complete. And so that on Wednesday when we meet, we really move towards decisions so that the administration can prepare a report that must go to the House for consideration. Honorable Lesoma. Honorable Lesoma.
Thank you very much, Chair. I was parking my hand until you finish your way forward. If you have concluded,
I have.
As I've been listening to you, thank you very much, Honorable Chair. I will humbly submit that we agree with your way forward and we meet on Wednesday. It will help because it will be of no use for the what we call it, the legal services to present the proposed bill while other honorable members, inverted commas, they feel that they still need to have the actual submissions, as it were. But I must register, Chair, that all of us, we are at liberty to access the mailbox, which does contain everything. But I will really humbly request that we align with your proposal as the way forward. Thank you very much.
Thank you, Honorable Lesoma, for being so proactive. Anyone who has a problem with that? I don't see anyone who has a problem with your... Yes. Yes, Honorable Gumede.
I don't know. This time my computer works differently. I don't know. There is something wrong. It doesn't allow me to raise the hand.
Oh, don't worry.
Chair, I agree with the summary as proposed by yourself, supported by Honorable Lesoma. I will request, one, that the legal service, when members seek mandate from their principals, at least a pager that in fact emphasizes the requirement of the bill. This is what you said, Chair, but you left it just like that. It will be important then why the bill, the third bill. That's one. Two, there was a request that this report that has been considered be circulated, that we consider that as well. Three, what has been requested as well is that some members are talking about the submissions that were 70, 90. It looks as if there is a balance and whatever. If ever there is any balance of such submissions that has not been given or handed over to members, let's then afford an opportunity that those members then get those submissions. And then lastly, Chair, is to keep on flagging, reminding that when we consider items on Tuesday program, I hope the program will then be forthcoming so that we know where are we heading to. That's my contribution for the day, Chair. Thank you very much for your sharing. That was excellent.
Honorable Gumede, I'm happy that although your computer is misbehaving, you followed the proceedings and you have made very important interventions, which I agree with. Firstly, the requirements, the revised bill dictates certain things which you define as requirements. I want to agree with you and formally request parliamentary legal services to set out clearly that if this bill, a revised bill, is acceptable, this would be the implications or requirements that we will have to comply with. That's perfect intervention. Secondly, I agree with you that the report must be circulated so that people digest it and internalize it, but there's no going back to reopening a discussion on the report because it has been accepted here. Lastly, I fully agree with you that we must take note of the fact that other members want to see all the submissions. We cannot stop them. They must satisfy themselves, but that is for their own good, not for holding this process. The process is going on because the report has been adopted. And thank you very much for that intervention. It's very helpful. Comrade Kawa.
Good morning, colleagues, and thank you very much for welcoming me. And Chair, I can see you are drawing to, you're about to conclude and adjourn the meeting. And but at the same time, I hear you talking about the bill, that bill, which has not been presented to this meeting. What are we going away to consult about if you have not if it has not been formally presented in this meeting? That is my question.
No, that's not even a question. I think it's a very useful intervention because I said that bill was produced by parliamentary legal services to aid consultations. And therefore, unless it is formally presented, how do you can go to principles and say this bill comes from this meeting. And anyway, what vindicates your intervention is the fact that in our program, we said that we're going to deal with the report and then receive a presentation on the bill so that we then refer that bill to members to use in their consultations. I think you are perfectly right. And I see Comrade Honorable Lesuma and Stein. I don't think that actually this is a matter of debate, because it was really a serious omission on our part, especially on my part. But I won't suppress those two hands. Honorable Stein.
Thank you, Chairperson. Chairperson, I think Honorable Kawa has said exactly what I said in the beginning, Chair. And I've never asked that we, go back and discuss all the submissions. My concern was about the words that said some were irrelevant. I think, Chairperson, I trust the committee secretariat and the people that must assist us with this. But at least if we can see that, and I'm happy with that decision that's taken for ourselves, because we, as you said earlier, represent the people, and people wrote to Parliament. And if we haven't seen the documents, it will just make myself more comfortable. Chairperson, can I also ask maybe if the Parliamentary Legal Services is on the platform to maybe just explain, and I've listened to you when you said that you made a proposal.
Sorry, there's a point of order. Honorable Gumede. Honorable Gumede. No, it's not. Yeah, proceed. Honorable
Chairperson,
Gumede.
it's just for myself on a... Can I proceed, Chair?
Is a point of order? If not, proceed.
Chairperson, it's just procedural purposes. I'm still asking, and I listen to you, Chair. I understand how we, from your side, are now sitting with a third draft. I would just find out from the Parliamentary Legal Services or Advocate Voyani to explain to us the processes according to Parliament's legal processes that we follow. I said earlier, it's the first time in my experience in Parliament that this situation has unfolded. I've never said that committee staff doesn't draft bills. They do, but after we have processed certain submissions. So the process to me is just very, very different to what I've experienced before, Chair, and I just want to understand the process that we are following, correct procedures at this stage, Chair. If we have discussed after we have now agreed on the draft document, the second draft bill, and then made proposals that for me would not have been procedurally problematic, but I do have a problem with the process that we are following. Thank you, Chairperson.
No. I think you are taking us back with respect. The matter on the table now is what Honorable Kawa raised. And I think that what we need to do going forward is that third draft must be officially presented so that it's part of the records, but not for the purpose of discussion now, but because it's part of the record for members to take it back for consultation. Honorable Lesoma and Honorable Melga. Hello.
Thank you very much, Honorable Chair. I think probably so that we don't agree on an item and then we go back to it. And there must be progress, because some of us will ever ask questions, which are good actually, because they make us a little bit sharper to this process. But I would say what Honorable Klaba was saying is that he reaffirms what we agreed on earlier on, that we'll stick to the agenda program. So we have concluded item 1. Now we are going to item 2. And hence I was agreeing with your good self, Chair, that let's take your summary in the first item. Let's go to the second question item so that we can have a progress, Chair. That will be my humble submission, Chair. Thank you very much.
I agree with you, but I will just allow Dr. Mulder, because he has raised his hand. That will be the only hand.
Yes,
Dr. Mulder?
Yes, thank you, Chairperson. I hear what the colleagues are saying. My problem is this. The agenda can't trump the parliamentary procedure. It's not possible. And I understand what we are trying to achieve. There's a document that was produced by the administration after being requested by the management team. Be that as it may. You would like to call it perhaps the third draft. I don't think it's a third draft. It's a proposal. It's just a proposal from management. Because if you look at it technically, what happened to the second draft then? The second draft was presented to the committee. We debated upon the second draft. We voted on the second draft. The second draft was then agreed by the committee with a majority vote from the ruling party. The second draft was then published for comment. We've received the comment. The second draft can't just disappear, and now we have a third draft. So I understand what we are trying to achieve. What you are basically saying is this is a proposal from management as drafted by the technical staff of the committee. And you want us to go to our principals and canvass them and say, what do you say about this proposal? But I don't think we could call it officially a third draft and the second draft just disappeared into thin air. Because if we do that, then the questions asked by the Honourable Steyn becomes very, very relevant. How did we get a third draft? So don't call it a third draft. It's a proposal from management drafted by the technical people, and you want us to get a mandate on those things. Thank you, sir.
Dr. Mulder, I fully agree with you. I think the proposal produced by the Parliamentary Legal Services was mandated by the MANCOM for the reasons that I explained later. But let's not debate whether it's a proposal or a revised draft. And then for argument's sake, let's say is a proposal. But that proposal must be officially presented. And that's what Honorable Kawa, seconded by Honorable Suma, say, because unless that proposal is presented, then it has no status. We can't refer it to our principals for consultation. I therefore call on Dr. Tuli to present the proposal that I refer to as the revised bill.
Chairperson, I will be presenting the draft.
Yeah, present it and bear in mind what Honorable Gumede requested, that we must have, what did he call it? We must have, let me see, a document showing the requirements that will be dictated by this proposal. Yeah, proceed.
Thank you, Chairperson. If the committee will allow me, I'm just going to try and switch my video off, just for the sake of bandwidth, and also I'll be looking at a different screen, so I might be confusing members.
Chair, on a point of order. Chair?
Yes. What are you saying?
On a point of order.
Yes, what is the point of order?
I just want to gather, is this a proposal an ANC proposal or ANC EFF proposal?
I repeatedly said, even yesterday, I repeatedly said that I'm not the chairperson of the EFF and the ANC coalition, if there's such a coalition. I'm the chair of this committee, and I only act in the interest of this committee based on what the Constitution, the law, and the rules of Parliament say. So there's no ANC here, there's no EFF. We sat in the management committee and we instructed the Parliamentary Legal Services to draft this report, and the Parliamentary Legal Services is the competent structure to do this work. So this document has been done by a competent structure in Parliament. And thank you very much. Let's proceed, Advocate Charmaine.
Thank you, Chairperson. I see that there is another hand raised. I don't know if you want to first.
Who is that? Who is raising the hand?
It's Dr. Lottery, Chairperson. Just a question of clarity before we proceed.
Mm-hmm.
Yes, thank you very much. I would just like to know before we go through this proposal, and you have stated a few times that it was the management committee that requested legal services to draft this. Could I just inquire what was the specific brief and which documents were used to decide on what is to be included in this proposal?
Dr. Lottery, I said that I don't interfere on substantive issues. I intervene, I guide in terms of the process. And the process was simply that we have a new report and the Parliamentary Legal Services should check if that report impacts on the second draft. And if there's an impact, then they must produce a proposal, to borrow the words of Dr. Mulder, produce a proposal incorporating the substantive issues that have been raised. So there was no brief. The only brief are the issues that come from the report. So Dr. Charmaine, proceed.
Thank you, Chairperson.
Advocate Charmaine.
Thank you. Members, yes, I think it is probably necessary just to give some context to this document. We were requested by the management committee to put something together based on reports. That in itself is not an easy task, because there were a number of submissions made. Some of those submissions we would need further wording. We would need further guidance from the committee. There were also some proposals that would propose, one for, one against, things like that. So we did try our best to give effect to as much as we can, and I will take members through the bill accordingly, and perhaps just expand a bit on certain of the aspects. If members would allow me, I think here at the long title, I don't want to go through the long title. I'd rather speak to these matters in the bill itself. But if I could start here and just say, look, there were other proposals for amendments as well. But what we tried our best to consider these. For instance, there were some proposals that would better fit in national legislation. For instance, the request for a measure to ensure a gender focus in land reform to favor women, because women have been really disadvantaged more so than men. They've actually still being disadvantaged in the setup as it is at the moment. There was also a submission on title deeds for people in rural areas, which is also something that would fit better in national legislation. Or in fact, in our view, of course, the committee might have a different view, and then we will simply need instructions in that regard. Some aspects were already provided for. There was submissions on mining and mineral reform to be included in the bill, but this is already taken care of under subsection 1. We have a very recent court case in this regard, and the resultant act that is currently operational on that. Some of the proposals would not have resulted in any change. For instance, if we add in subsection 4 the word other before reforms, the sentence still reads the same. So that kind of proposal we did not include in this bill. Then there was some where we did not agree with the legal argument behind it. There was a request for subsection 1 to be amended to indicate that nil compensation might be arbitrary. But we are of the view that currently nil compensation is provided for in the Constitution. It is not arbitrary. And the fact of deprivation not being arbitrary is something that we feel forms part of the basic structure of our Constitution. And to amend that would definitely have an impact in respect of whether this bill would comply with the basic structure doctrine. There were a couple of things that we did not include, but would need instructions from the committee before we ventured there. Things like adding timelines to subsection 9, which deals with national legislation that must be enacted. Changes to factors in subsection 3, and then another exemption that was requested in respect of land being held for religious reasons. Some of the other aspects, in fact, when I go through it now, the two that we did include, I will speak to them when I get specifically to those. On the long title itself, all of these amendments are related to amendments that are made in the bill. So they're consequential. So that's why I'm not going to go through them specifically. The only change that is specific to the long title is this aspect of changing the word provide to stipulate the circumstances. And this was simply a proposal to make the bill read a bit easier. If I then go to the preamble, as you would have noticed from the previous presentation, there was a lot of concern about the preamble, how it is worded, whether it is a correct reflection. And we tried to look at what was said and try to word it as was requested by the public. For instance, on this first paragraph, there were comments that it is not only the dispossessed that are of the view that little is done, and therefore this sentence, this portion of the sentence here should be deleted. So that is one proposal that is on the table based on public inputs. From the third paragraph here, looking at arbitrary disposition of land, this is consequential, and I will speak to that when I get to subsection 7. The same in respect of excludes communal land. I will speak to that when I get to the first clause. And yeah, so I will speak to those because they are consequential. The last paragraph here, productive, the concern was raised by the public that to include productive here excludes a large number of participants from the ambit of the preamble. I need to just stress at this point in time that we need to keep in mind that a preamble does not create rights and obligations. So your preamble ideally should give the background to the bill, and it is not something that would necessarily make the content of the bill exclude certain people. But the concern was still that not all land reform is for the purposes of agricultural land reform, where you would want someone to actually deliver, make food, and so on. So that was why the request was for productive to be removed. And the same argument then in respect of to not just speak about agricultural land reform, but to speak of agricultural and other land reform. Then this last part is to provide for state custodianship. There was a concern that because we mention ownership in this paragraph, that we are by implication saying that it can't be done through state custodianship. So that is why we added this sentence here in an attempt to make it clear what this is about. And then we've added this as a transitional measure. The wording itself was not proposed by the public, but the public was indicating that there needs to be clarity on state custodianship. And from the proposals that were made in respect of draft 2, this is how it was explained, that state custodianship will be transitional. It will be the first step in order to ensure that people will be able to get ownership of land. So, of course, like I say, this wording is just an attempt from our side to give effect. It will be for the committee in the end to decide whether this solves the concerns that the public raised, whether it's the right wording, whether we should tweak it, and so on. If I then go to the actual clauses of this proposal, on the first clause, paragraph A, clause 1, paragraph A. Now this amendment comes from draft 1 already. In draft 2, we removed the words in accordance with subsection A, and there was a request for that to be included again into the bill. Now, there's also a proposal for amendments to subsection 3A, and unless those proposals are in fact accepted, we cannot link this subparagraph or this paragraph with subsection 3A. And I think I will rather explain it at 3A because it becomes consequential to some extent. Just to make it clear that there was a request that it be linked back to and 3A, just to remind members, deals with the circumstances to be in national legislation. But this inclusion here, like I say, is dependent on what happens with 3A. Then there was a lot of requests for the removal of improvements on land. Now, the inclusion of improvements resulted from the very first workshop that this committee held, where it was proposed that improvements should be included. The comments made were that on the one hand, land already includes any improvements that are fixed thereon. It is a doctrine that is part of our law. It becomes part of the land. Other arguments were that improvements brings another aspect to the whole situation of compensation, and it should be considered separately. And accordingly, this is then what it will look like if the committee agrees that improvements should be removed from the bill. Then there was a proposal for communal land specifically to be excluded from this situation where expropriation for purposes of land reform the compensation may be nil. The wording that we proposed, should the committee accept this exclusion, is that it then reads, provided that in accordance with subsection 3, where land, other than communal land held by or for the benefit of a traditional community is expropriated. Now, the wording here again, it is open for discussion and so on. We try to provide for situations where a community might currently or in future hold land for themselves in a form of ownership. So that is why we didn't say own. We put the word held by a traditional community, simply because it is not, there might be changes in how this works in future, and we don't want to change the constitution every time the practice on the ground changes. So that is what we have there. Then just to indicate, there were concerns about the removal of the word courts in this paragraph. We did not reinsert the wording of courts, simply because the reason it was removed is not that we're removing the role of the courts. And a number of submissions acknowledged that the removal of the word courts in this edition here does not oust the role of the courts. And that is absolutely correct, because here we have the role of a court. It is there. This provision is just in respect of then the compensation. So in draft 1, we included court, and that then resulted in a possible interpretation that only courts may make a decision on nil compensation. And the problem with that, of course, is that we then totally exclude the executive from this situation. And it means that even where there is agreement on nil compensation, parties would have had to go to the court. So so that is why we did not include the court. One last thing that I want to add on this clause, in respect of communal land held by, or not in respect of that as much, but there was also another comment in respect of a requirement for the transfer of ownership, a title deeds to be taken away from this held in a communal concept, whether in a trust or something else, and rather to give people individual title deeds. But again, that is something that is probably better suited in national legislation, but of course it is something that the committee may instruct us on. In respect of the next subsection, the next paragraph rather of clause 1, there were no issues raised in respect of this that hasn't already been raised. And therefore we did not include any amendments, but of course the committee may instruct us otherwise. Now, in respect of the insertion of subsection 3A, and this is here where I'm saying this is the decision that will inform if we can refer to section 3A, subsection 3A in the first paragraph A, or not. And the concern that is raised was first off that the role of courts are excluded. But if we look at this here, subsection 2, that means that the courts are still involved. You can still take a matter to the court. The question, of course, is on what? And what we have, if compensation is nil in your national legislation, that would be such circumstances where there would be no need for a discretion. It would be clear cut that this is a situation where compensation will be nil. If we thus retain the word is, we cannot include a reference to this subsection in our main amendment up here. Then we will have to remove that. But if we agree, if the committee says, yes, we would rather want this to be may be, then we can include it up top. So like I'm saying, the courts aren't ousted, but what could perhaps be difficult for the legislature when it comes to considering national legislation is to actually find circumstances where it is clear cut that compensation should be nil and that there's no matter of discretion involved. So it is something perhaps that the committee could consider to rather change the word from is to maybe, but definitely it is not a matter that the court's role is excluded. It is just in respect of what it is excluded, and it makes the national legislation a little bit more difficult to draft. The other thing that was raised by the public in respect of subsection 3A was whether this is necessary at all. And we will, the committee members will remember that this also was raised on the second draft, on the first draft. And the question was, they were like sort of threefold. The one was saying this is not necessary at all. You need to say nothing here. Automatically, you can put it in national legislation if you want to. There was another view that said, in fact, you should not even refer to national legislation. This bill should include the list here. And then the third view is sort of a hybrid or a compromise between the two situations to say, no, we need to say that there must be national legislation that will provide for this. And again, like I said, this is something for the committee to decide on and then give us instructions so that we can make the necessary amendments to this. The next proposed amendment is on subsection 4A. And there were lots of comments that this 4A and the way that it is worded and making the land a resource, we should actually not include it here. It should rather go to section 24 of the Constitution, which deals with the environment. But look, I don't see, the committee is busy with section 25. If it feels that this is appropriate for section 25, then we can include it here. Another comment that was just made was that it shouldn't just be land. It should be natural resources. And this, of course, is something that would then align subsection 4A with other subsections in section 25, which speaks to things like water and so on. So that is a proposal there. There was also a concern about whether land isn't too vague and that it should be defined. Another proposal was that it should be only land owned by the state that is deemed to be the common heritage of all citizens. I don't think that land owned by the state as the common heritage actually reflects the intent with this sentence. But again, this is something for the committee to instruct us on. and then we will do the necessary amendments. The last aspect on the draft 2 as it was, so the last amendment that's directly related to subsection, to the second draft, is in respect of subsection 5. Now, here there was a concern that the phrases certain land as well as state custodianship is not clear enough, and that they should be specifically defined. Now, if they need to be defined, we will need instructions on what that wording has to be. Like I said, when I discussed the long title or the preamble, we attempted something to include as a transitional measure in respect of state custodianship in order to indicate that this is what was intended with the wording. But it is for the committee to decide on that and to give us finality, a final decision on that, whether it should be made perhaps rather be defined. We can then make this paragraph A and add a B, which will define it. But we'll just need the wording, of course, from the committee. Then the last proposed amendment is in relation to the cutoff date of 19 June 1913. In this regard, there were proposals for the removal and proposals against the removal. The public did not specifically give us a date of 1800. This was proposed by the chairperson, and I suppose it is in relation to discussion, to open up discussion and give the public something to comment to. So I don't think I need to say much more about this. The proposal was, and we're all aware of why there's a concern with this 19 June 1913 cutoff date. We're also all aware of why the date was decided on initially. And this, of course, is absolutely a policy decision. And then just in respect of the way forward, this amendment here, the subsection 7, as well as the exclusion of communal land, are material amendments. All the other amendments are things that are related to draft 2. It comes from the public submissions. It is in an attempt to approve the bill, or like with improvements, to reject a policy that was stated. And none of these would require further consultation. The committee could accept those changes and proceed with to adopt the bill and vote on it clause by clause and finalize the bill. But the exclusion of communal land, if the committee agrees that that must be included, the same in respect of subsection 7. And of course, the other matters that I've mentioned that we don't have instructions on yet, the issue of agenda focus, title deeds, mining and mineral reform, timelines, changes to factors in subsection 3, and exemption for religious reasons, all of those would constitute material amendments. And because of that, the courts have indicated that the committee will then have to go back to the public and to advertise these for comment from the public. So just in case members want to have a look at the relevant cases, the first case is that of Trueworths versus the Minister of sorry, I'm just looking for my document. The first matter is that of Trueworths versus the Minister of Trade and Industry, and in that aspect, the department included certain changes to regulations based on public inputs. And the court then said the specific changes that were made weren't in fact material changes, but the court did indicate if it was a material change, it would have had to be published for further comment. The next case is that of the South African Veterinary Association, which is the Speaker of the National Assembly, which dealt with the Medicines and Related Substances Amendment Act. In this situation, there was a request from the public to include veterinarians in the amendment bill. And even though they are included in the act, the court found that this inclusion, because it was a new aspect to the bill, because it extended the bill, and it was a material amendment, it would have had to be advertised and the public's input sought in order to comply with Section 52 of the Constitution. So it is based on those two cases that we are saying that all these material amendments will have to be advertised. I'm also of the view that subsection 7, that the committee will have to request permission for the scope of the bill to be extended. So if the committee agrees to make any material amendments, which could include 7 or the exclusion of communal land or the other matters that I've mentioned, the committee will have to request an extension from the House in respect of its lifespan and its mandate. The reason for that is, firstly, the public consultations, the public needs at least 3 weeks. That's in accordance with the rules. We cannot introduce the bill before 30 days in terms of Section 74(5) of the Constitution, but the rules indicate 3 weeks for publication and a call for comments. But further than that, the National House of Traditional and Khoisan leaders will also have to be consulted, and the act that affects them will actually provide them with 60 days to comment, and that is something that will also have to be taken into account. Now, in this occasion, the committee, or rather the National House, did in fact respond in time. They've already responded, even though their return date is only next month, but we already have this submission. However, I would not advise the committee to ask for an extension that accepts that there will be a quick response. I think it is necessary to take into account that the Act allows them for 60 days and that the extension should then keep that date in mind. Lastly, Section 74(5) requires the committee to also consult the provincial legislatures on any new amendments and, of course, the departments in terms of the National Assembly rules. So those would be the processes going forward. And if I may just quickly summarize, there's 3 options before the committee. The one would be to make no amendments to draft 2. Simply go clause by clause, adopt the bill, report on it, and submit it to the House. The second option would be to accept only those amendments that do not constitute material amendments, or some of them, not even all of them, or make others that are not material, but adopt a bill that is tweaked rather than amended. With that option, the committee can instruct us to make those final tweaks. The committee can then go clause by clause through the bill, adopt the bill, and report on the bill. The third option before the committee is to adopt amendments that are material in nature, such as the removal of the 1913 date and the exclusion of communal land. And in that case, the committee will need to advertise. In respect of 1913, the committee will also have to request the House for permission to extend the scope of the bill. Not in respect of communal land, because I'm of the view that communal land, although it is a material amendment, is not extending the scope of the bill. It is still the same material that we're working with. But if the committee then asks for that extension in respect of material amendments, we will have to publish. It will have to go to the provincial legislatures for comments. The departments will have to be called to comment. National House of Traditional and Khoisan leaders will have to be given an opportunity to comment. Their period is the longest. That is the 60 days that has to be kept in mind. So those are the proposals as they are set in here, where they come from, what we considered, what we couldn't consider at this point in time, as well as the way forward. Chair, I hope that satisfied, I think, my brief in this presentation. I hope that I have covered everything that was requested. Thank you.
Advocate, I must thank you very, very much for good work done. And also for guiding us on the options that are available to us and how we should go about prosecuting those options. But to the members, I want to say the following before I allow you to comment. Firstly, that I agree with Advocate van der Merwe that the changes made are consequential, the amendments made are consequential amendments. Secondly, that to do other things, the Parliamentary Legal Services will need instruction from this committee. But before this committee gives such instructions, the committee itself needs to consult, members need to consult their principals and apply their minds to the issues raised. And therefore, it would not be possible, in my view, in this meeting, for the members to give any instructions to Parliamentary Legal Services, because firstly, they have not yet consulted. Secondly, they have not yet applied their minds. Those would be the two requirements to be met before any instructions can be given to the committee. And also, to give another example, if you want to exclude religious areas, we repeatedly asked religious people to appear before us. This matter is also very complex. Maybe it must be made part of the consultation, because I know of a place called Lehalola Manzuba in the Free State, the cave of Manzuba, which is a sacred cave for the practitioners of African traditional religions. But because the British were in charge, they didn't recognize African religion. They built an Anglican center on top of an African center. And in the Free State again, at Mutobo, a farmer owns a farm where a sacred site of the African practitioners of African religion is situated. In Venda, at Pipidi Falls, which is a sacred area where African religion is practiced. People are developing a tourism project on top of a religious. Now, if you then, off the cuff, say you are protecting religion, you will actually be protecting the mainstream religion, even where they have violated the religion of the indigenous people. And that would not be fair if we understand that we have got to address the injustices of the past. Now, what am I saying? In short, I am saying the legal services have done sterling work, but